Good day, viewers. It's a very, great honor to have you guys watching once again. And today we are going to be considering a very, very, crucial and important, aspect of real estate. At times, this, particular section of real estate can be so controversial, very risky, and at the same time it is super important to any real estate transactions. And what am I talking about? I'm talking about what? Land titles. So today we're going to consider what are land titles and what documents are not land titles. So basically we have various land titles. Each one has their own significance, what they stand for, the level of interest that they have, level of power that they have. So we are going to consider today. So we all know basically that land is the most important factor of production in economics. It is crucial to carefully select what land you want to buy, where you want to buy it, and most importantly, what title does that land have. Remember I said the land you want to buy, where you want to buy the land, and most importantly, what title does that land have before you make any investment decision, especially on land. And this is Lagos State. There are a whole lot of plethora of issues that can come up if one does not do the proper due diligence before going ahead with any investment decision. So if you're new to our channel and you're watching us for the first time, kindly subscribe now, like the video, and also turn on the notification bell. And if you have been watching our channel in the past and you're watching again, kindly subscribe now, turn on the notification bell, and also like this video. And you might even share to friends, people who might be interested, who this video might be of help to, especially for those who want to make an investment decision in real estate. And make sure you watch this video to the end, because there are a whole lot of value that I'm going to be giving you in this particular video. So there are different titles in land, which is a documentary evidence to show the ownership of the land which the seller wants to sell. And it basically tells you, oh, this land belongs to this person, and you have the documents back it up. So in real estate, basically there are various steps to take when any potential buyer or any piece of property is about to be sold, be it house, be it just a bare land. There are certain steps that any buyer should take. One is that you must make a search at the land registry. That is very, very critical. If a land has a particular title, you have been informed that the land has a particular title, also do your own due diligence. Better safe than sorry. Do your own due diligence, confirm. And how do you do this? You have to contact the land registry, whereby you can check who the owner of the land or the owner of property is, be it land or building. Like I said, what type of title the owner has on that particular land or property. Even if it's a developer or it's an individual owner, you need to confirm all these things. Also, you also have to consider how the said owner got the title to the property. You need to consider that. And then you also check whether there is any encumbrance or any encumbrance on the property. And examples of this could be, maybe there is a subject matter of maybe mortgage or pending legal activities or issues on the land. These are things you need to check for, because there can be encumbrance on land that an ignorant buyer may not know about, and might just fall into the traps or errors of these particular mistakes. Then you also need to consider whether the property is under government acquisition. So at times there are lands whereby governments would have designated for maybe military zone, or they have a plan they want to use it for. Those kind of lands are not safe, except if the government has declared otherwise, and there are processes to this for them to declare that okay, this land is no longer under the acquisition. Then decide the property. So, but what we want to consider today are titles basically on land. So you've seen the brief introduction that I've done concerning this. So now one thing that establishes the title on lands in the Nigerian real estate market. Anywhere in Nigeria, be it Lagos, Abuja, Ogun State, any state in Nigeria, is a document known as the Land Use Act number 6 of 1978. That book, as small as it is, contains several laws that governs, the land market within Nigeria, on who has control or rights on land and things like that. Because one thing the Land Use Act has done is that, it has conferred the total lands within the confines of each state to the governor of the state. It's more like putting it in trust of the governor of the state for the beneficiaries. Who are these beneficiaries? The citizens. It's just to put the land in trust for the citizenry, so that if anyone wants to own lands, they can easily get access to it. And that is why the governor has that the land of the whole state under his purview. And that is what I'm just giving you a brief interpretation of what the Land Use Act is actually talking about. And then, so the first title we are going to consider today is actually the excision. Now, the excision is a very important title in its own right. So, because basically what happens is, at times, when there is for instance, let's just say there is a land now which belongs to a particular family, and when you made research on it, you discovered, oh, this land has an excision. So what the excision basically means is that you're taking a part from a whole, and that part has been exercised. So what it means is this: at times, government could take a land and feel, okay, let's give part of this land to this particular family, maybe the family that was first situated in that particular community. And when government is doing this, it means that the land has been, that particular portion of the land has been exercised to that particular family. Now, one thing that you also need to notice is this: even when a land is exercised to a family, and it has not been gazetted, it is still very risky to invest in such land. So when you want to invest in a property, and they tell you this land has an excision, it must be a gazetted excision. I know a gazette is an official book, is a record book of the government, where all special government activities or are detailed and are clearly spelled out and recorded. So because in that gazette to be recorded that, okay, yeah, the government actually gave this land to this particular family, so that one, it is safe. So for instance, if one is buying a land, if the land is not having excision, it could still mean that the land can still be seized by the government anytime if there is no excision on it and the family claims to own it. So one must consider all the very intricacies. And one thing is this: a gazette is a very powerful instrument that the community owns the land. It indicates that, okay, yes, this particular community owns the land, and they can always go ahead and replace the gazette excision with a C of O. That's in the place of trying to perfect the title, but we'll still get to the C of O matter. And there are a host of very important criteria that one needs to pay attention to when investing on lands that have gazette or things like that. So now we're also going to consider some things. So basically, I'm going to say this: deed of assignment is not a title to land. It's not an actual title that protects one's land from government acquisition or whatever. No. What a deed of assignment or a conveyance documentation does is it only shows the transfer of interest in a property or in a land from the assignor, which is the landowner, to the assignee, which is the potential buyer or the new buyer. So if anybody is telling you that a deed of assignment is a title, please, it is not. So you have to consider that. That is just by the way. I just felt I need to chip that in because it doesn't in any way form a title to land. One can go ahead, after, if the land has been, well documented. Maybe you have an annexation on it, you have a C of O. So when you're trying to maybe like get some necessary perfection on that documentation, one can now go ahead, get a governor's consent on it. But I will still get all those parts. So now let us consider the certificate of occupancy, which is another very important title. In fact, it is, I see it as one of the most important titles in land. So a certificate of occupancy, also widely called C of O, just for short, is always issued by the state government officials. And in other words, in its real sense, if you take it in its real substance as spelled out by the law, the certificate of occupancy, because in section 22 of the Land Use Act number 6 of 1978, it has given lots of powers to the state government, to see to land matters within the confines or within the borders of any state in Nigeria. So basically, what the certificate of occupancy is actually indicating, or is implying, is that the government is giving you this land for a term certain, which is what, 99 years duration. Meaning that, okay, yeah, your land is secure for this period of 99 years. And it would already indicate a host of information, because we have some things, one that they call statutory right of occupancy, which is more, that one is majorly issued by states or local government councils. But certificate of occupancy is basically issued by the state government, and this would link the name of the owner, the year it was created. If it's a family owned, it will put it in the family's name, and a host of other information that you need to know, where the land is situated and things like that. The certificate of occupancy is going to spell that all out for you, so that when you are making your findings, or when you're making your search at the land registry, you would get full details, or to know, you get full information on what and who owns any land you want to invest in. So basically, the certificate of occupancy is a very powerful documentation. And one thing you should also know is that the document cannot be issued twice. Once it is issued, it is issued. So for instance, if I'm buying a land that already has a certificate of occupancy, and because some people have asked me this question in the past, that can I get certificate of occupancy on a land that already has a certificate of occupancy? And the answer is no, because the government will not issue it twice. So if a certificate of occupancy is issued on a land for a period of 99 years, if anybody or any new person buys that land, it will not start counting again from the beginning. No, it is still that same period of 99 years. So let's say maybe the first owner who got the certificate of occupancy has used a period of 9 years. The remaining period left on that certificate of occupancy is 90 years, because it's only for a term certain, which is what, 99 years. So that is one about the certificate of occupancy. Now, another very important title to land, which is very critical, is the governor's consent. And the governor's consent is an integral part of any land transaction. It is one of the steps required to perfect land title in Nigeria. The other steps could involve stamping, registration, but the concept of the governor's consent can be found also in the Land Use Act number 6 of 1978. And these laws govern land transactions in Nigeria. The consent basically is just the governor giving consent to a land transaction that has happened between the buyer and the seller, meaning that the governor is aware, or the government is aware of this particular transaction that has occurred between the assigner and the assignee. That is what the governor's consent is all about. And before you can get the governor's consent, you must have had a very, very good title on your land, be it the certificate of occupancy or the accession, the gazetted accession to be specific. That would help you avoid a lot of hassles within. So like I said, if you go through the Land Use Act, you will see it in section 22, where it is clearly spelled out the powers in which the certificate of occupancy has. Now, I'm going to make a disclaimer, which is very, very important. Purchase receipt is not a title to land. Survey plan is not a title to land, because at times even surveys can be fraudulently, created. So you need to, pay close attention to most of these information that I'm, dishing out to you. And in a later video, I would still do more contents on, this title. Maybe in some videos, I would, talk on a single title to explain it deeper for you, our viewers. So we've come to the end of this video. I hope you have been able to glean, important informations that you can use for any of your land transactions or your property transactions in general. So if you have further questions about this, you can always, send me a DM. My numbers have been displayed on the screen. You can also check the link of this video, the description of this video, to get my direct WhatsApp link. So you can just message me directly, and I'll provide more details or more information that you might require on this particular land titles. So if you haven't subscribed, please kindly subscribe to our channel, because we are going to be giving more value oriented informations like this to you, from time to time, so you don't miss out on any of our updates. I remain Matthew Oshati. Thank you for watching. Stay safe, and bye for now.